For the record, before the court, numbers 4 and 5, 𝗲𝗏 versus Aidan Kearney, 23 CR 313, 24 CR 43. Mr. Kearney is present, along with his attorneys, Timothy Bradel and Mark Bederow. The 𝗲𝗏 is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for a bail hearing. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the 𝗲𝗏.
Hi, Mr. Cosgrove.
Hello, Your Honor. Tim Bradel on behalf of Aidan Kearney to my left.
Okay.
Good afternoon, Your Honor. Mark Bederow for Mr. Kearney.
All right. Good afternoon, gentlemen. You can be seated. Mr. Cosgrove, I've seen the video. Go right ahead.
All right. Well, thank you, Your Honor, for hearing us today. I have a couple of things that I would like to do. Your Honor has seen the video. I want to put some observations about the contents of that video on record, and I want to draw on the police report, a copy of which I have provided to counsel. I'm going to read excerpts from it that I think are significant because aside from summarizing the contents of that video for the record, they also summarize somewhat the reactions of the Alberts upon viewing that video. Lieutenant Tully's report would indicate that at approximately 8:15 in the morning yesterday, he spoke with Chris Albert, who, as Your Honor knows, is a witness in the open Superior Court case of Commonwealth versus Karen Reed. Yesterday in the presentation, I referred to a number of incidents which Mr. Kearney was indicted for, which the Commonwealth alleges constituted intimidation of the witness with respect to Mr. Albert and with respect to his son and to other witnesses in this trial as well. And I made reference at that time to the videos, which I believe you have been provided by Mr. Bradel in his filing that were played before the grand jury that record some of the background. And I think that's important, Your Honor, because if we're talking about, to draw an analogy, Chinese water torture, it's not the current drip, it's the accumulation. And I think whatever one thinks of this video, it has to be placed in that context. Lieutenant Tully continues that Mr. Chris Albert, who I will refer now to avoid confusion simply as Chris, sent him emails with 2 videos from March 4th. They are from his restaurant, D&E Pizza, on 618 Washington Street in Canton, depicting Mr. Kearney. One video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is located next to D&E Pizza at 614 Washington Street. And a group is seen leaving C.F. McCarthy's that later joins Mr. Kearney. Mr. Kearney stops in front of D&E and places his face next to the front glass window of D&E. An interior camera captures Kearney standing close to the glass, staring into the camera for approximately 25 seconds. A male with that group then exited C.F. McCarthy's and joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. The audio is captured by an exterior camera. The sound of occasional passing motor vehicles obscures the audio, but Lieutenant Tully could discern what he describes as the following statements made by Kearney. And I pause at this point to put on record what the court already knows, which is that subsequent to the Lieutenant Tully's composing this report, we made efforts to merge the 2 videos into one video and to enhance the audio. So that is what Your Honor was presented with. The videos themselves were not changed in any way, but they were merged, so essentially you see them both playing at the same time, and you hear an enhanced audio, which in my view is still not great. As Lieutenant Tully heard it, Mr. Kearney said this: "Hi, Chris. What have you done? Murdered. Something's inaudible. Misses you. Wishes he was alive today. He would be. Why did you do that, Chris? Chris, why did you tell the jury that you got home? Why did you say you went upstairs and then waited 15 minutes? Then Colin came home. Colin didn't make it home until at least 12:45, Chris. It was Colin, Chris. Colin. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands up to herself, too." Those are the statements he made in his conduct standing outside D&E Pizza. Similar to the conduct that was the basis for his indictment, and Your Honor has probably viewed at this point the video of the defendant standing outside D&E Pizza accusing both of these parties of murder. When Chris saw the video shortly after the incident, he became upset. He stated he's upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him and his son. And that's basically the report, Your Honor. Your Honor, there are two Aidan Kearneys. There is the courtroom Aidan Kearney, as is presented by counsel. He is careful only to exercise his First Amendment rights, and in no way does he have anything to do with the things that have happened continuously to the victims in this case as a result of his continuing broadcasts and other activities that have continued since his indictment. If Jennifer McCabe is getting anonymous letters threatening her, Your Honor, with having her head chopped off in prison, if her daughter's school is getting phone calls and letters asking her professors if they knew they have sitting in their class the daughter of a murderer, if Mr. Albert is getting phone calls, if people are photographing him on the street and sending those photographs when he's trying to enjoy his dinner or he's at the beach to Mr.
Honor,
Kearney,
I
who
object.
posts them,
Okay, your objection is noted. Go right ahead, Mr. Cosgrove.
Who
We'll hear from you later, Mr. Bradle.
who posts them on the internet, that has nothing to do with him. He's only responsible for his own conduct. Your Honor, a few days ago, Mr. Kearney was standing outside this courtroom, waiting for a Karen Reed hearing, which he was covering in his supposed role as a reporter. As he went up, he was filmed by another one of the Karen Reed supporters. He was filmed for a, quote, live show by 𝗵𝗵𝗂𝗋𝗋. He's a Reed supporter and a YouTube personality. And this video of Mr. Kearney's interview was subsequently posted on one of the free Karen Reed video shows. I watched that video, and I wrote down what Mr. Kearney said just about 2 weeks ago. It was brought to his attention by the interviewer in a friendly way that word had leaked out that all of the threatened actions by the U.S. Attorney's Office, which the witnesses in this case have been threatened with, they're going to be indicted, they're going to be marched to jail. District Attorney Morrissey's phone is being tapped. The police are corrupt, they're all going to be indicted. That investigation, if it ever was an investigation, had concluded with nothing, zero, nada. Mr. Kearney was asked about that, which at that time was a rumor. And here's what he said. They all know what they did. It's just so obvious. Like I said yesterday, if they are never charged, okay, they got away with murder. Congratulations, they got away with it. But I have successfully made it. So no matter where they go in public, if they walk into a restaurant, the people will always look at them funny, and they will be like, oh, there's the people that murdered John O'Keefe. When they walk into a restaurant and they look around them, they have to be thinking, who here thinks I'm a murderer?
Judge, I object. I move to strike. Counsel, is he counsel for the Commonwealth? Is he a witness testifying? I have no notice of any of this stuff. What's going on here?
Okay.
I have
Your
no
objection's
paperwork.
noted. I'll hear from you, as I said earlier, Mr. Bradel. Go right ahead. Mr. Cosgrove, what's your recommendation? What do you think?
What's my recommendation? My recommendation, Your Honor, is one, that the court enter a stay-away order with respect to any property in which any of the witnesses in the Reed case for the Commonwealth or in any of the pending indictments against Mr. Kearney, and that stay-away order require him to remain a distance of at least 100 yards from any of those locations. My second recommendation is that the court enter an order with respect to all of those same people, the witnesses for the Commonwealth in the Reed case, the witnesses in all of the currently pending indictments against Mr. Kearney, that there be no contact with any of those victims, direct or indirect, through a third party, by any means whatsoever. And I hesitate, given my own respect for the First Amendment, to make any recommendation as to what Mr. Kearney can say. However, I note that to accuse someone of murder, is defamation per se. It's a tort. It's not the only tort that Mr. Kearney has committed along the way. There's been invasion of privacy. There have been others. A witness can come to me and say, what can I do? What can I do to stop this? I didn't sign up for this. I agreed to testify. I answered your questions. I agreed to go into court. I agreed to be cross-examined, redirected, challenged. I didn't sign up for 2 continuous years of shame. Now, I don't know what I do, Your Honor. I don't know if I say to them, well, I'll tell you what. Get yourself over to the civil court, file a civil suit, you get a pretty good defamation case against Mr. Kearney. And after you pay a lawyer $10,000, $50,000, whatever the going rate, maybe you'll find somebody to take it on contingency. And after you've been deposed, and after you've sat in court and been to court a number of times, and after there's a trial, you might collect a pretty handsome amount of damages. Of course, that's going to be 2 or 3 years down the line. But I am helpless, Mr. Witness, in a criminal case to remedy it. I think that's all just First Amendment stuff. That's not intimidation of witness. I'm not sure what I do, Your Honor, but I'm going to ask you also to set a condition that there is to be no defamation of any of these witnesses. Finally, I'm going to ask you to set some bail in this case. I was not involved in the case. I understand a request for bail was made originally, and for some technical reason, it was not allowed. And I acknowledge that Mr. Kearney, since he has been indicted, has been faithful about showing up to court. I have no reason to think that he will not show up to court in the future. I think he regards it as another opportunity to put on the Aidan Kearney show outside. But I do note that he's facing charges that carry substantial penalties, that are felonies, and that if a jury should see it my way after trial, I put the defense and the court on notice that I see his conduct since these indictments have been brought as aggravating circumstances, and I will certainly take that into consideration if I ever have the opportunity to make a sentencing recommendation. I would suggest what would be a nominal bail, 10,000 surety, 1,000 cash, but pray your Honor's judgment in that respect.
Okay.
If I could say just one final thing.
Go right ahead. You go right ahead.
I think I'll think better of it, Your Honor. Mr. Bradel can bring to the court's attention what I was about to tell him if he wishes, and I will not get into discussions with counsel.
Okay. Mr. Bradel.
Thank you very much, Your Honor. So, Judge, just a procedural objection. There's no paperwork before the court. There's nothing supported by affidavit. I'm just hearing counsel's recommendations right now. So I'm responding to this on Mr. Kearney's behalf, basically off the top of our collective heads here. So that's kind of where we're at, and I would just object procedurally. Nonetheless, we have, a lot we want to say. It's hard to sit here and listen to the Commonwealth with scorn, say that he wants to put on the Aidan Kearney show. Well, yeah, you're darn right he wants to put on the Aidan Kearney show. It's his First Amendment rights to do so. And the Commonwealth, for a year and a half now, has made every possible effort based on their own self-interest. The particular prosecutors, the particular state police detective unit, present prosecutor accepted, to suppress a viewpoint that's been raised against those very same people. So that's what we have here at the outset, Your Honor. As far as this particular motion goes, how far are we going to let the Commonwealth surf this wave? You saw the video. The case at bar, Your Honor, had no stay-away order from Judge Krupp, had zero bail, nothing, not even the stay-away orders, Your Honor. Mr. Kearney was not in violation of anything whatsoever when he did what he did. And in terms of the government, again, out of their own self-interest to suppress his critical viewpoint of them, the government wants to try to tell the court that this is witness intimidation. And as we comprehensively argued and briefed just yesterday, this is not witness intimidation. And the purpose of bail, Your Honor, is not to punish under Section 57 of the bail statute that governs Superior Court in Commonwealth versus Brangen. There is no allowance for punishment. Nonetheless, Your Honor, Mr. Kearney has agreed under Section 87 to stay away. And he's agreeing to stay away from the pizza shop, agreeing to stay away from Mr. Albert. But I should say, Judge, again, this goes to how far are they going to surf this wave? Chris Albert and Colin Albert, Your Honor, are no shrinking violets. They're on camera threatening Mr. Kearney, threatening to kick his ass up and down the street in 2 seconds, calling him a pussy. These people are not shrinking violets. They're only shrinking violets when they see an avenue to strike out at Mr. Kearney. And now, was it unwise what he did? Yeah, you wouldn't have done it, I wouldn't have done it. Nonetheless, what do you do about it? You don't punish someone, you can't punish them for it. Look at his track record. He's not a flight risk. He has no record whatsoever. He comes exactly when he's called, anytime he's called to answer for this case, and he always will. And he's got kids in Worcester and he lives in Worcester and Southie, and he's not going to have any sort of flight risk issues. Nonetheless, under Section 87, Your Honor, we would agree, preserving any procedural objections, we would agree under Section 87, Your Honor, to stay away orders from the witnesses, stay away orders in this case and in the 24 matter as well. However, there's one thing that we're very concerned about, Your Honor, is that there's been a history of these witnesses using these types of orders to flush Mr. Kearney out of court. And we ask that you look at, in terms of an agreement, Your Honor, under 87, we would propose that the court adopt Judge Pomeroy's order across the street, which was stay away, but not with respect to courthouses, so Mr. Kearney can do his job, and so they can't abuse any court orders to flush him out of court to stop him from covering these cases. So I would ask that you by agreement, again, allow him to stay 100 feet away from these people. And in terms of courthouses, he's allowed to be in any courthouse of the Commonwealth plus 300 feet curtilage, so he can come and go without accusations, such as we are actually dealing with in another case, Your Honor. But that is essentially Judge Pomeroy's order, and we would be agreeable to that under Section 87.
So say that again. Give me Judge Pomeroy's order again.
Sure. The gist of it, I'm not saying it's 100% accurate. The gist of it is that he can go, Mr. Kearney can go to any Commonwealth courthouse without worrying about the stay-away order, and within 300-foot curtilage, so he can come and go without these accusations that he's violating some order. And that's essentially what Judge Pomeroy did, and we are agreeable to that here under Section 87 in light of what's transpired, and reserving the rights, of course, to address this as these allegations as having nothing to do with witness intimidation. There's no threat, there's no fighting words. He's talking into a window at 10:30 at night. And again, you might not do it, I might not do it. Unwise, sure. But what do you do with it? You can't surf this wave for miles and miles here. It's ridiculous. And he's acknowledged it, he's agreeing to it. I ask that you would adopt our suggestion, Judge, and let it be. Thank you.
Okay. Thank you both for your presentations. I'll note a few things for the record. I watched the video. Unlike some of the things that we talked about yesterday that were in the enumerated allegations of the indictments on the 2023 case, there wasn't any camera that was being used by Mr. Kearney. There was no content creation. I still do have to look at it, I suppose, under the First Amendment and balance that with what Mr. Cosgrove has said about the witness intimidation in the case. I also note that Mr. Kearney has two cases that are pending before this court and one that's pending across the street, as Mr. Bradel referenced, in the district court. It may result in a fourth case for his actions the other night. I don't in any way, I've taken a look at his record, which doesn't have much of a record. I also take into account that he has been to court on every single occasion. He's always here with counsel, and my view of him, he's always behaved according to the way that one is supposed to behave in court. So I certainly respect the Commonwealth's recommendation in the case, and what I am going to do is I'm going to make a further order on this case that he's to stay away from all of the witnesses who are enumerated in the counts of the 2023 case, and also for the witness who is enumerated in the count of the 2024 case. He's to stay away from those witnesses. He's also to stay 100 yards away from D&E Pizza. And I think that what Judge Pomeroy has ruled upon about his coming into the courthouse. He comes into the courthouse as a journalist, but I'm going to suggest that when he comes into this courthouse, that he behaves according to the sentiments that have been expressed here. And my order to him is that he's to behave in an appropriate manner and not to in any way try to intimidate or harass any witness. And that would also extend to 300 feet around the courthouse so that he can get in and out of the courthouse during the Reed trial. So that's my order on the case.
Judge, may I ask, in terms of the stay-away order, and I think this is typical, are you accepting the defense team, investigators, et cetera, if we need to talk to witnesses?
Absolutely. The defense team can reach out to witnesses if they want. That's what defense attorneys have to do to defend their clients. So you can have an investigator, or yourself, Mr. Bradel, or learned counsel, Mr. Betterow, as well.
Thank you.
But I don't want anybody else to be reaching out to witnesses.
I understand, Your Honor.
I also have a question.
Go right ahead, Mr.
I don't mean
Cosgrove.
to press Your Honor too
Yeah.
hard on this, but I noticed as you announced your decision, you indicated 100-yard stay-away zone
From the B&E pizza,
from
D&E
B&E Pizza, which
Yeah.
I appreciate. I think it would be very advisable to extend the same order with respect to the homes of the witnesses in these cases, given the history.
Let me talk to Mr. Bradel about that.
Can I have one moment, Your Honor?
Yeah, why don't you talk to your client?
Judge, we'll agree to that under Section 87, yes.
That's
absolutely.
fine.
Thank you.
Okay, so it would be the same thing, 100 yards away from the homes of the witnesses in the case. Why don't you give me a next date that works for all counsel on the case? We still have the matter from yesterday under advisement.
Judge, we have, just reminding everyone that you mentioned that 10 days we want to address or file pleadings relative to the journalist issue in the taint team. Should we pick a date maybe 20 days out, 30 days out?
I'd say probably sometime at the end of April.
End of April. Okay.
What, April 23rd?
I'm not a good week, Madam Clerk. Could we go the next week?
That's fine.
April 1st, or, I'm sorry, April 30th.
That works for us.
All right.
Unfortunately, I've neglected to bring my calendar with me, so why don't we say April 30th, and if there's a problem, I'll consult with Mr. Bradel and get back
That's
to the
fine.
court.
Okay.
That'll be
Thank you.
that'll be a two-
Thank you.
Thank you, Your Honor.
All right.
Kearney, your conditions of release are amended as you are ordered to stay away, have no contact, direct or indirect, from all the witnesses in your 2023 and your 2024 cases. You're also ordered to stay 100 yards from D&A Pizza and the residences of all the victims, the witnesses in these cases. And you are ordered to behave in an appropriate manner while in the courthouse and 300 yards of the curtilage. Do you assent to those conditions, sir?
Yeah.
And you're hereby notified if you're charged with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Laws, Chapter 276, Section 58, and your matter is continued to April 30th at 2 p.m. For hearing on any motions. Thank you.